Hey guys, welcome to this video. We're going to go over a recent case that came out. This is brought under the FCRA, the Fair Credit Reporting Act. Not so much with normal credit reports, but with a background check. And that is covered under the FCRA. So let's take a look at this. March 26, 2021, so just a few weeks ago. And let me give you sort of the lay of the land here. The defendant tried to dismiss the case by saying that the plaintiff had no standing, had no actual injury here, and the court ultimately rejects that. But I want you to see, because it does illustrate something very interesting about these background checks. So we have the defendant's motion dismissed due to lack of standing, and the court says, I'm going to deny that. So the plaintiff applied for employment, and then February 13, the defendant offered employment, but it was contingent on satisfactory references and background checks. And then on February 17th, so it's just 4 days later, this background company did the background check, and the defendant then revoked the employment offer. And the defendant said, your background check did not meet the company requirements, and a report will be sent to you from Sterling. Sterling's the background company. So what does the plaintiff say? The plaintiff says, defendant took an adverse action without giving me the chance to address whatever the issues were in the report or dispute it. And this is your common practice, and you immediately and unequivocally reject the applicant before sending the background report and without providing the applicant an opportunity for discussion. And the plaintiff says this violates 15 U.S.C. section 1681 B and then paren B3. And so this was brought as a class action. So what is this 12B1? This is the argument that the defendant's making for his lack of standing. And that says if there's a lack of jurisdiction over the subject matter, usually we call this subject matter jurisdiction. So there's subject matter jurisdiction, that's power of the court over the case, and there's personal jurisdiction, that's power over the parties. Okay, we're not talking about personal jurisdiction here. So when you're challenged a motion dismissed, plaintiff's burden to prove the existence of subject matter jurisdiction. And there's two types. There's facial and then factual. So a facial challenge is just looking at the complaint, nothing else. A factual challenge is when we're looking at evidence outside the pleadings. The pleadings will be the complaint and the answer, but really we're just talking about the complaint. To resolve factual disputes, and then the court has to weigh the evidence. And the judge says, look, this is a facial attack. So all we're looking at is the complaint here. So why are we talking about standing? This comes up in almost every federal court case, unless you do what we do, which is we file the cases in state court, and then they get removed to federal court, and we don't deal with this nonsense. But if you file it directly in federal court, almost every defendant will challenge standing. So the Constitution says we have to deal only with cases or controversies. This is Article 3. So this is known as standing. And there are three things you have to show. Number one, an injury that is concrete and particularized. So not just it affects everybody in the world, but it affects me. So that's number one. Number two, a causal relationship between that injury and the conduct that you say is wrong. So you got to be able to tie, here's what the defendant did wrong, and here's that particularized injury, specific injury to me. And then number three, that the injury can be redressed. In other words, this is not a moot issue. This is something you can actually get an award of damages. Might be nominal damages. And if you have an interest in this, I'll go over the recent U.S. Supreme Court case, fascinating case involving religious free speech. And the question came up, could nominal damages be enough for this element of redressability? So just let me know if you're interested in that. So the real issue here is not number three or number two, but it's number one. Is this concrete and specific enough? So it must affect the plaintiff in a personal and individualized way. And it has to be real, not abstract. It's got to be actual, not theoretical. Concrete, not amorphous. Unfortunately, all of those terms are pretty amorphous, and that's why the courts are all over the place about this. So this says the plaintiff bears the burden of alleging sufficient facts to demonstrate standing. The only sort of correction I would make to that is that's true if the plaintiff filed the suit in federal court. But if the plaintiff files suit in state court, and the defendant is removing you to federal court, which they have the right to do, they have to show that they're standing because they're the ones that are sort of knocking on the federal courthouse doors. But what the judge is saying here is true 99% of the time. So alleging a bare procedural violation of federal statute is not enough. And this is the famous case, and this is what we typically call it, a Spokio challenge. Article 3 standing requires concrete injury even in the context of statutory violation. So if you've not suffered a genuine harm or risk of harm, there's no business entertaining this lawsuit. So the Sixth Circuit, and this is a case out of Northern District of Ohio, so Sixth Circuit is their appellate court and federal court, says, well, there's two broad categories. Number one, a violation of procedural right is sufficient because Congress conferred the procedural right to protect a plaintiff's concrete interest, and the procedural violation presents a material risk of harm to that interest. Or the second option is it's just a bare procedural violation and you've got to have additional harm. So the defendant says, well, this is category 2. So yeah, you got a violation, but you've got to have something on top of that. So bare procedural injury and the bare procedural violation is insufficient. The plaintiff says, no, this is category number 1, because this type of statute is designed to address a specific harm, and that's all I need. And says, we'll look at decisions from the 3rd and 7th Circuits. Those appellate courts reject the defendant's argument. And the judge says, I think you're right. So let's look at the actual statute. In this, even if we're not particularly interested in standing, but again, if you file directly in federal court, you got to understand standing. This is a fascinating part of the FCRA. And I want you to see this. So employers, before taking adverse action based on a report, they shall provide the consumer a copy of the report. So it says, all right, you do a background check on somebody, you get that report, you better not fire them, but not hire them, or if they worked for you and you fire them, whatever the adverse action is, before you do that, you better give the report to them. It's pretty simple. That's what you have to do. And judge says, it's clear. Before an employer takes adverse action based in any part on a consumer report, and a background screening report would be a consumer report, consumer has a right to receive a description of his rights under the FCR as well as a copy of the report. And the judge points out, noticeably absent from this section is any reference to the accuracy. So we don't really care about the accuracy. It's not that, well, they have to give you a report if it has errors in it. They just have to give you the report before taking an adverse action. And so here the 7th Circuit says, this particular section is different than other sections. This section does not link accuracy concerns and disclosure obligations imposed on employers. So various courts throughout the country have analyzed this. Many courts have concluded violation of this part of the FCRA is sufficient to establish standing. And says, indeed, the 6th Circuit, which is where the judge is, would seem to agree. It goes through this Huff versus Telecheck. Ultimately, the Huff court said the plaintiff could not demonstrate under a different section an actual consequence or real risk. But here, plaintiff did suffer an actual consequence. Well, what was that? The withdrawal of an employment offer. And the future conduct was impacted by not having the report prior to the adverse decision. So this is really key, what I have highlighted in red here. This section seeks to protect the consumer's future conduct. The statute mandates disclosure of a report before an adverse decision. Thus, failure to disclose a report is much different than a technical error with the report itself. So let's see what the plaintiff says. So there's 2 emails on February 17. The first from the reporting agency says, hey, there's an issue. The second from the defendant notifies plaintiff that defendant considered plaintiff unqualified based on his background report, and a report will, that's future, will be sent to you from the background company. So court says the metaphorical right hand and the left hand, they don't know what's going on here. Because at some point during these 2 emails, there's only 2 hours separating them, defendant made an adverse decision not to hire the plaintiff. But that was before the plaintiff received a copy of his background report. Therefore, you violated the law. Pretty simple. You have to send a copy of the report and then take an adverse action. If they had done that, it'd be a totally different story. But here they took the adverse action and then sent the report. It's a violation of the law. And the defendant has two arguments here. First, they say you should have alleged the report was inaccurate. A lot of times with the FCRA, you do have to have a claim, say there was an inaccuracy, but not here. It's not concerned with the accuracy. So it's just immaterial to your rights. All it's saying is you have to get the report, whether it's accurate or inaccurate. You have to get the report before they take action against you. And second, the defendant says plaintiff should have alleged that it would have made a difference. In other words, you got the report and you would have argued this and the defendant would have changed its mind. The court says, no, that doesn't matter for standing. The statute gives plaintiff the right to receive his report before defendant made its adverse decision. Thus, a future right is implicated. What he would have done with that report or what he may do is an issue for the merits. In other words, not this standing issue. And the court points out, hey, defendant, you didn't address these two pretty major cases here. And so this section protects the concrete interest of consumers and plaintiff adequately, has pled sufficient facts to demonstrate violated his interest, protects consumers' concrete interest receiving background reports before an employer takes adverse action. So you've alleged enough, and the court says this doesn't have any bearing on sort of the merits of the case. So here's the name of the case again. It is David Helwig versus Concentrix Corporation, United States District Court, Northern District of Ohio, March 26, 2021. So hope you found that interesting just to see how this particular section works. And this is why we have to be very, very precise with the FCRA, because what's true in this section may be different than the section right next to it. So appreciate you guys watching this. And if you want more information on these background screening type reports, if you're interested in this, I do have a few other case decisions, but just let me know and I'll make a point to do some more of these or to do sort of an overview or a webinar on this and get into the details of it. So you guys have a great weekend and I'll talk to you soon. Bye-bye.